Facts alleged against the Law Society of Alberta. 3. In the alleged breach of the Charter Section 15, the LSA Appeal Committee behaved in a fundamentally unfair manner towards the appellant, failed to properly consider whether the February 6, 2019 LSA complaint dismissal 44 by the LSA Conduct Committee of the June 6, 2018 LSA complaint by the appellant was reasonable or correct, whether S.J. Bykwich lied to the LSA in her March 25, 2019 LSA complaint reply about never seeing the destroyed exhibits S1, respondent copy, whether S.J. Bykwich acted dishonestly and in bad faith by destroying the relevant inculpatory evidence relating to the CPSA, L.R. Allhauser, and C.D. Boyer, and the exculpatory evidence relating to A.J. Arkey, with the potential evidentiary value, in contravention of the Criminal Code of Canada Section 139 and Section 341, and the LSA Code of Conduct Section 5.1-9, C, and Section 5.1-10, whether that failure was an ethical violation. Whether there existed the reasonable apprehension of the bias and the conflict of interest with regards to the relationship between the LSA, the Attorney General of Alberta, D.R. Cranston, R. Armstrong, D. Thompson, L.R. Allhauser, G. Buick, W. Pavlik, V. Melnick, L. Silenko, D. J. Boyer, Douglas, D. J. Boyer, Donald, and C. D. Boyer, and due to those relationships, whether S.J. Bykwich and others should have been investigated by the LSA Independent Counsel, with respect to the rules of the LSA Rule 87.2 and Rule 87.3, whether the members of the LSA Conduct Committee, S. Eames and S. Roach, improperly withheld the documents with the time-limited response from the appellant 45 and improperly delayed their February 6, 2019 complaint dismissal of the June 6, 2018 complaint against S.J. Bykwich that allowed for the 2019.02 term expiration of the LSA President, former litigation representative of A.J. Arkey, D.R. Cranston of Bennett Jones 46 and deliberately omitted to correctly interpret the impugned LSA Code of Conduct and rules of the LSA statutory provisions, nor reference the underlying issue, mischaracterized the spoliation of evidence complaint against S.J. Bykwich 47 therefore, was fundamentally unfair in their April 11, 2019 LSA appeal dismissal 48 unreasonable and incorrect, thus rendering that decision illegitimate, and with respect to the Alberta Rules of Court Rule 3.15, originating application for judicial review 49 was properly subjected to the judicial review in the Court of Queen's Bench of Alberta file number 1903 to 21485. Law Society of Alberta. 88. There are the numerous matters that have given rise to a reasonable apprehension of bias in the April 11, 2019 LSA appeal dismissal that support the appeal of the January 20, 2020 application dismissals. In Baker v. Law Society of Upper Canada, 1999, at page 1, that stated 198. 89 in Tran v. CPSA, 2018, at paragraph 6, that stated 199. 90. The biased April 11, 2019 LSA appeal panel process was conducted in a fundamentally unfair manner, and was therefore unreasonable, incorrect, and illegitimate. The June 6, 2018 complaint by the appellant against S.J. Bykwich for the alleged contraventions of the LSA Code of Conduct was deliberately mischaracterized and dismissed 8 months after, on February 6, 2019. With the abuse of the rules of the LSA Rule 87.2 and Rule 87.3, the LSA appeal. 31. Committee failed to order the investigation by the LSA Independent Counsel. A review under the Legal Profession Act Section 53, review by Executive Director 200 should have been referred and assigned to the Independent Counsel by the LSA President, D.R. Cranston, because of his previous relationship with A.J. Arkey, and the relationship between the LSA Executive Director, D. Thompson, L.R. Allhauser, and the LSA Public Representative Lay Venture 201 successor of L.R. Allhauser, G. Buick, who appointed B. Melnick, W. Pavlik, and L. Way Silenco, to preside over the November 16, 2018 LSA Appeal Dismissal 202 of the December 1, 2017 complaint against C.D. Boyer. 203 due to that reasonable suspicion of bias. In the April 10, 2019 letter to the LSA, 204 and the October 25, 2019 brief and authorities of the applicant, the appellant invoked the Nemo Judex rule against the overextended appointment of L. Way Silenco to the LSA appeal panels on November 16, 2018, by G. Buick, and on April 11, 2019, by W. Pavlik. The right-minded people, informed of the facts, would think that there would be a reasonable likelihood of bias in that second appointment of L. Way Silenco. In French v. Law Society of Upper Canada, 1973, at pages 29 to 30, that stated 205. 91 in Ringrose v. CPSA, 1977, at page 815, that stated 206. 92 at pages 817 to 818, that stated 207. 93 as a result of the praise by D. Thompson of L. R. Alhauser in the February 15, 2014 LSA news release, and because the LSA president at the time of the complaints by the appellant against C.D. Boyer and S.J. Bykwich was D.R. Cranston, former litigation representative of A.J.R. Key, D. Thompson should have been of the view that was not appropriate that he conduct a review under that section of that Legal Profession Act. In neither the April 11, 2019 LSA appeal dismissal, nor in the November 22, 2019 LSA letter to Court of Queen's Bench of Alberta, is there any mention of the LSA Independent Counsel requested by the appellant in the March 8, 2019 LSA Appeal 208A, the April 10, 2019 letter to the LSA, the October 24, 2019 brief and authorities of the applicant 208B, and reiterated in the December 12, 2019 written response of the appellant. However, in the December 19, 2019 LSA written reply, at page 3, that stated 20994. At page 4, that stated 210. 95 The LSA falsely indicated that the matter does not meet the criteria for the independent counsel investigation with respect to the rules of the LSA Rule 87.2. The marked departure from the criteria required for the independent counsel investigation is evident with the provision of 32. The independent counsel in Gray, Schultz, and the LSA, 2017, 211A, and the prosecution in Krieger v. LSA, 2002, .211b key directly involves the LSA President, Executive Director, 3 Conduct Committee members, 6 benchers, 211c, 2 agents of an honorary bencher, and 2 members. The criteria reached for the LSA Independent Counsel investigation in Key far exceeds that of Gray. In Key, S.J. Bykwich, an agent of an honorary bencher 212, the Attorney General of Alberta, is the Chief Crown Prosecutor who is alleged to have contravened the LSA Code of Conduct Rule 5.1-9, C, and Rule 5.1-10, by improperly destroying the inculpatory and exculpatory evidence provided in the Exhibits S1, respondent copy, that was intended for the special prosecutions, for the failure to comply with the September 21, 2017 notice to obtain record of proceedings, and for lying to the LSA Appeal Panel, on March 25, 2019, about never seeing the evidence that she is accused of improperly destroying. The criteria reached for the LSA investigation and prosecution in Key far exceeds that of Krieger. 96 The respondents and the Court of Queen's Bench of Alberta stated that the request by the appellant for the court-ordered independent counsel investigation is impossible. However, our jurisprudence in Doucet-Boudreau provides otherwise. The court in Canada has long exercised the jurisdiction to supervise the court order of an injunction. In Doucet-Boudreau v. Nova Scotia, Department of Education, 2003, at paragraph 70, that stated 213. 97 at paragraphs 55 to 59, that stated 214. 98 in Key, With respect to the Charter Section 24 enforcement, the court is invited to supervise the court-ordered LSA Independent Counsel investigation by an unbiased and competent outside counsel from a province outside of Alberta with an exceptional record for the legal integrity. 215 In Doucet-Boudreau, the Supreme Court of Canada ordered that the court does have the jurisdiction to supervise the court-ordered injunctions to ensure the adherence to the court order relating to a charter breach, in provision of a Charter Section 24 remedy. Having brought the administration of justice in the province of Alberta into the disrepute, the LSA have demonstrated their collective incompetence and complete lack of integrity to investigate a matter of the extreme reasonable apprehension of bias and conflict of interest within their organization, have lost deference with that regard, and now require the unbiased and competent court-ordered LSA Independent Counsel, from outside of the province of Alberta, to investigate that matter. 99 The relief sought by the appellant against the respondents include: A. Certiorari. A. The appellant seeks the certiorari in the judicial review to quash the illegitimate April 11, 2019 LSA appeal dismissal. B. Injunction. The appellant seeks the injunction for the court-ordered and supervised LSA Independent Counsel investigation with respect to the rules of the LSA Rule 87.2, 1a, and Rule 87.3, to investigate the alleged contravention by SJ by which of the LSA Code of Conduct Section 5.1-9, c, and Section 5.1 to 10. B. D. Declaration. A. The appellant seeks the declaration from the court that the respondents abused the Civil Practice Note No. 7, paragraph 6. B. The appellant seeks the declaration from the court that the LSA and the Attorney General of Alberta breached his Charter Section 15 equality rights, and that the CPSA breached the Charter Section 15 equality rights of AJRK.